Hello, everyone,
There
and
we go.
welcome to another live session with immigrationquestions.com. In these sessions, we cover important topics for immigrants, both documented and undocumented, focusing on legal status in the United States. Our goal is to answer as many of your questions as possible. I'm Nikita, and I'll be your host for today. Have you been living in the United States for years, building a life, but still haven't become a permanent resident? Maybe you've heard terms like adjustment of status, but aren't sure where to start. If this sounds familiar, you're not alone. Today, we'll walk you through the process and show you that it's not as complicated as it seems. Today's topic: a step by step guide to adjustment of status. We thoughtfully designed this to clarify this part and show you how it's not just achievable but manageable. Today, we're joined by a seasoned immigration attorney with over 15 years of experience. He is licensed to practice in Massachusetts, Ontario, Canada, and is fluent in English, Greek, and French. He is also an active member of key organizations like the Massachusetts Bar Association, the American Immigration Lawyers Association, New England, and the Law Society of Ontario. Let's give a warm welcome to Attorney Philip Paradisis. We're so thrilled to have you here today.
Thank you very much for having me. I really appreciate it.
To everyone watching, get ready for an exciting session. Grab your notepads and pens and let's dive in. Attorney Philip, for those who might not be familiar, what exactly is adjustment of status and who qualifies for it?
So when we talk about adjustment of status, we are talking about people that are here in the United States and that are looking to apply for permanent residency, otherwise known as the green card. This allows people to complete the
Interesting.
process here without having to go back to their home country and apply for the visa back home. There are certain important components of adjustment of status. Number one, and I think the most important, is that you have to have made a lawful entry the last time you entered the United States. So that means you've come in with some kind of a visa or some kind of parole program, but you have to have been inspected and allowed into the country. At the same time, you have to maintain that status, not only up until the time you file your application, but also until USCIS actually is able to approve the application. Now, we also have to be careful and make sure that we do not fall out of status. In other words, we don't want to overstay our visa. We don't want to violate whatever terms of the specific visa are. And we need to make sure that if we need to change visa categories, we do so in a timely manner. In terms of eligibility, there are certain categories of people that are eligible for adjustment of status. The classic example is the family-based adjustment of status. That includes the spouse, children, and parents of US citizens. For that category, visa numbers are unlimited, they're immediately available, and generally speaking, as long as you can establish the relationship and provide the supporting documents, you should be able to ultimately get approved. There's also employment-based categories. There are multiple variations of that. And there are two other categories that are a little bit smaller. If you've been approved for asylum, you may be able to apply for adjustment of status. And there's a category called special immigrant status. Those are certain categories of people that have been approved for these statuses and can then subsequently apply. We have to have a visa available to us at the time we apply and at the time that USCIS will be approving our applications. And we have to make sure that nothing disqualifies us from being approved. That means that we have to be admissible to the US, meaning that they have to have allowed us in properly. We don't have any serious criminal records in our past, and we are also not a threat to national security.
Interesting. Attorney Philip, once someone determines their eligibility, what are the main steps involved? Could you walk us through the process of them filing forms to the green card
Sure,
interview?
of course. So the main form that we use to file for adjustment of status is Form I-485. That's the principal form. Now, at the same time, depending on the eligibility category, we need a sponsor. If it's a family-based application, the sponsor will be filing Form I-130. If it's an employment-based application, the form is Form I-140. When we are talking about the family law context, we also need the sponsor to file the affidavit of support. What that means is that they show that they have enough money to support the intending immigrant for a certain period of time. And the idea here is that the government does not want new immigrants to immediately fall onto public benefits the moment they step foot in the country. So the sponsor, the parent, the spouse, the child assumes that responsibility. At the same time, with both of these categories, whether it's family-based or employment-based, we can also apply for a work authorization and what is called the travel document, which allows someone to travel while their application is being evaluated by USCIS.
That actually brings me to my next question. Documents are always a big concern. What specific evidence should applicants prepare, and what are some common pitfalls to avoid during this
So
phase?
again, with respect to documents, it always depends on the category under which you're applying. But let's start with the family-based process. So if your spouse is applying for you, then other than your own passport, proof of lawful entry, and birth certificate, you need to be able to prove that you are in a real marriage with this person and that you are not simply using them to get a green card. The parental relationship, whether it's a parent applying for the child or whether the child is applying for the parent, is a little bit easier because you just need to establish paternity or that you are actually the child of this person, and then just show that you've maintained that parental relationship over the years. On the employment context, again, on the employment side, there are several different variations of employment applications, but generally speaking, you would show things like proof of a job offer, proof of income, and in some cases, if necessary, what is called the labor certification. Some categories require that. I won't go into the details because it's a show in and of itself, but those are some of the evidence that you would need to show. With respect to pitfalls, the most important thing is incomplete forms, whether questions are not answered or whether questions are answered incorrectly. I always advise my clients to also be very careful and to always answer the questions truthfully. Whether you think it will hurt you or whether you think it will help you, the truth is that the US government can find out whatever information they need to find out. And so when you apply, it's not the time to try to hide things, because if they catch you in a misrepresentation or in an outright lie, you will not be getting the benefit at all. The second big thing that we see is that people do not provide enough documentation to support the category under which they are applying. So again, in the family law context, you have to prove the marriage, you have to prove that you are indeed the son or the parent of the US citizen sponsor. And on the employment side, you have to show that you have a job offer, that the employer is willing to hire you and sponsor you for the green card, and so on. Number three, USCIS, if they're not satisfied with the initial application, they issue what are called requests for evidence. This asks the person to submit more information in support of their application. And what we see is either people do not provide adequate information, or, which is probably worse, they miss the deadline given to them by USCIS to reply. Number four, and this is a generally new requirement, at this time, USCIS requires that you submit your medical examination with your original application. In the past, they used to issue requests for evidence for this, but now they want it right at the very beginning. Two more things very quickly. What that we see: falling out of status or not keeping your status valid. And lastly, if you are called in for an interview, you have to be prepared. You have to do some homework in advance. You have to review your forms. You have to know exactly what you put in there, and you have to be able to answer any question that they ask you.
Okay. So we know that sometimes things don't go as planned. How should applicants handle delays, like RFEs or other obstacles that may arise
All right,
during
so
the
the biggest
process?
key I tell my clients is patience. This immigration is a lengthy process as it is. It's always subject to the political winds that happen to be blowing on any given time period, and that could also affect the timeline. I always tell people, don't compare yourself to either other people that you know or other people that you hear about, because just because they have a quick process, it doesn't mean that you are in the same category just because you are filing for the same thing. You may have complications in your case that they did not. Um, People need to monitor the status of their application. They have to be proactive, check the USCIS website with a receipt number, see what's happening. And also be proactive. If you need to contact USCIS for whatever reason, contact them. Now, once a delay becomes unreasonable, then at that point, you have the option of considering to actually sue USCIS in federal court. I would advise, however, for that step, you should always do it with an attorney, because they need to determine whether it's a good idea to do so at that particular time and talk to you about some of the potential consequences. RFEs. Number one and most important, understand what immigration is asking for. Is it documents? Is it explanations of certain things in your background? You need to understand that, and you need to respond completely to whatever it is they're asking and within the deadline that they give. I generally tell people, go through the RFE step by step and address each of the points that they mentioned. If your RFE is complex because they're asking for a lot of things and you have a complicated background, seek assistance from someone that can help you, an attorney that knows and has experience in doing this. Obstacles. If your personal situation changes, you have to consider whether you need to inform USCIS. Very quickly, for example, if you're married to a US citizen and the marriage falls apart, there are circumstances where that application just cannot move forward, and there are circumstances where you might be able to move on your own. Criminal issues. If you have any criminal issue in your past, they have to be resolved, and you have to disclose it as part of your application. Don't try to hide it. If you need to provide an explanation as to what happened and how it was resolved, you need to do that.
That is fantastic advice. Thank you so much for that, Attorney Philip. Welcome to our audience. If you're just joining us, we're thrilled to have Attorney Philip with us today, a respected immigration expert who's contributed greatly to today's topic. This is immigrationquestions.com, a platform that makes immigration easier. Ask your questions in any language and get connected with a verified attorney who can provide legal guidance. You may even get a free confidential consultation. Just visit www.immigrationquestion.com and sign up today. Attorney Philip, as someone who helps immigrants every day, what are your thoughts on immigrationquestions.com and how it supports the immigrant community, both documented and undocumented?
Well, I think that the site is a very valuable resource for people that are trying to gain some basic understanding of the immigration process. I think the camaraderie of having people ask questions and having other people and attorneys answer those questions is a very valuable service. Um, I think it's an excellent starting point. And again, I think if your situation is fairly straightforward, you can probably use the information that you're given and move forward with your application. However, and I caution everybody, if the case is complicated for whatever reason, either because of past issues or current issues, you need to go beyond the forum and really get the advice of an attorney that can help you navigate through all of this.
Thank you for that, Attorney Philip. This has been a great conversation. And now it's time for questions and answers. Drop your questions in the chat and we'll answer as many as we can. Or if you'd like to ask live, call us on 516 703 3483. Attorney Philip, before we head into the Q&A, we all know preparing for a green card interview can be nerve-wracking. So what are your top tips for applicants to ensure they're ready and confident?
The first tip is know your application. Okay, that means that once you've submitted everything to USCIS, make a copy for yourself. Don't just rely on what you remember. Make a copy and before the interview, go over the application. If you identify any errors, make a list on a piece of paper, and when you get to that interview, hand it to the officer right at the beginning. Understand that the interview is the time to make corrections to the application and to reveal anything that you may not have revealed as part of the application. Of course, with that point, be careful, right? You don't want to come across as having hidden something from immigration, but if it's an oversight, if you're filling the form out on a PDF and somehow it doesn't print or whatever the issue is, just explain it to the officer. That's the point of the interview. In the context of a family-based adjustment of status application, especially a marriage-based one, your spouse has to be on board, and you and your spouse have to have a full understanding of the application form and of your relationship. You need to know key dates. You need to know when the last time you went on a trip together was. Where did you go? Were there other people there? And so on. Normally, as an immigration attorney, I give my clients a list of questions that we see most often, and I ask them to do homework together. At the end of the day, your answers have to match, and that's what immigration is looking for. Discrepancies between the husband and the wife in that context.
Thank you, Attorney Philip. So we have a question from Dimitri. He's asking, how long will it take to get a green card through adjustment of status? And can I work as I wait?
So, Dimitri, how long it takes? The process generally takes from about 8 months all the way to 15, 18, and even 24 months. Again, it depends on the category. It depends on the overall political situation. And that's why I mentioned earlier that patience is key. With respect to working during adjustment of status, yes, in most categories, you can apply for work authorization at the time that you file your application. These normally get approved somewhere between 4 to 6 months after you apply.
Thank you for that, Sunny. Philip, we have another question from Amelia. She says, my application has been pending for more than 1 year. How can I make it faster, or should I worry about
All
denial?
right. So first of all, Emilia, thank you for the question. You say that it's been more than a year. I don't know what kind of application you filed. What I would say, what I am seeing on the ground right now, in most cases, family-based applications are somewhere between 12 and 15 months, and work uh, employment-based applications are anywhere from about 18 months to 24 months, depending on the category. So I don't think necessarily you need to worry, but what I would suggest, if you go to the USCIS website, they give a timeline for each of the application forms and the amount of time they expect it to take. That will give you a good rule of thumb. If you are outside of that timeline, then you can certainly start pursuing them a little bit more aggressively to get an answer and a decision on the application.
Thank you, Attorney Philip. We have another question from Barry. He asks, what will happen if I submit the wrong information on my adjustment of status application? Can I correct it?
Again, Barry, I would say it depends on the information. I mean, typos or dates, for example, if you don't remember 100% what a date was, those are generally not a big problem. And you can certainly, as I said, just review the application before the interview, make a note on a piece of paper and just hand it to the officer. Tell them that you need to make these corrections. If the errors or the oversights are more serious, so for example, if you have a lengthy criminal record and you've answered no to questions that ask whether you've been arrested or detained, that could potentially be more serious. And if you notice something like that, I would encourage you to consult a lawyer and attend the interview with an attorney so they can try to resolve those situations.
I was arrested a few years ago for a small issue but not convicted. Will it affect my adjustment of status process?
It could. So criminal issues within the immigration concept are complicated. Now, you say it was a small issue and you were not convicted. That sounds like it was probably a misdemeanor. They probably had you pay some kind of fine or do some kind of community service. If that's the case, then most likely it will not affect you. But you do need to disclose it, and you do need to provide to immigration a copy of what is called the disposition. So you would go to the court where the issue was dealt with, and you would ask them for the disposition, which shows what the case was and how it was ultimately resolved.
That's quite insightful, Attorney Philip. We have another one from Pascal. It says, can my children also adjust their status with me if they're already in America?
So, Pascal, the answer generally is probably. Again, I don't know what category we're talking about. I'm assuming you might be talking about a family-based application. If it's through a spouse, and if you were married to the spouse before the children turn 18, then they are in effect considered children of your spouse as well and can therefore be included in the application. If you get married over the age of 18, that's a little bit more complicated. And if you are in the employment-based context, then yes, normally children can be included with the parent because it's the employer that is sponsoring them.
Thank you for that, Attorney Philip. We have another one from Joyce. It says, if I didn't mention my spouse in the original petition, can I add them to my adjustment of status application later?
So, Joyce, you say you didn't mention your spouse in the original petition. I'm not exactly sure what that means. I don't know if your spouse was the U.S. citizen, which it sounds like that's the case. Um, I'm not sure at what stage in the process you did not mention the spouse, but potentially it could be a problem. So I would consult with an attorney so they can see exactly what it is you are referring to.
That's quite insightful, Attorney Philip. I think that's all the questions for today, and that's a wrap. Um, Actually, we have
Okay.
another one.
Mhm.
Ibrahim, how are you doing, sir? I'm living in Kuwait right now, and how can I get a lottery visa to the US? Because was working for US government on base in Kuwait, so I want to move to the US, and how can I get a
All right.
visa?
So Ibrahim, that's a bit of a complicated question. Again, depending on the country and depending on the role you had in working with the US government, there may be certain programs that you could potentially take advantage of. Again, I would encourage you to have a consultation with an attorney so that you can go over the entire history and see what options you might have.
Okay, I think that was our last question for today. Thank you all so much for joining us, and a special thank you to our guest speaker for sharing his time and expertise. We hope today's session on a step by step guide to adjustment of status was helpful. Visit immigrationquestions.com to connect with your experienced attorneys who can guide you through your immigration journey. If you missed anything or want to rewatch, check out our recording on Spotify by searching Borderless Talk by immigrationquestions.com. Join us next week for another great session on employment based immigration with Renata Castro, who will discuss pathways to legalization, options for those out of status. You won't want to miss it. Once again, thank you so much, Attorney Philip Paradisis. We can't wait to have you back.
Thank you, Nikita. It's been a pleasure. I really appreciate it, and I look forward to seeing you again.
Thank you so much. Have a wonderful afternoon and see you next week. Stay informed and empowered on your